Hello students, welcome to yet another interesting episode of Recitals in-Depth, where we are going to cover the topics which have featured in the month of July 2024 for the subject of polity and governance. The topics are broadly falling under the themes of Parliament and its key legislations, judiciary and important judgments, fundamental rights, and finally, governmental schemes and policies. Hello students, welcome to the Recitals in-Depth. So these are the topics that we are going to discuss in today's episode. So topics are belonging from various broader themes, and ultimately our approach towards this topic is going to be the same that we had been following in the previous sessions as well, where we are going to discuss every topic in quite depth and we'll try to understand its application with respect to the mains and prelims. So now let us start with the first topic, and a very interesting one, that is Kawar Yatra. So basically one very important directive by the UP government has been issued with respect to this Kawar Yatra and the management of the Kawar Yatra, which was not well received by various stakeholders with respect to its management. So now let us try to understand what is this particular issue. So for every issue, we'll be firstly looking into the various structures that we are going to follow for learning this particular topic. So to start with, we'll see what is this issue all about. Secondly, we'll try to understand what is this Kawar Yatra, its cultural significance, its history and its origin. Thirdly, we'll try to understand this, what is this government directive which is creating a trouble, or which has landed this governmental directive in respect to the Supreme Court of India, in front of Supreme Court of India. And lastly, what did the Supreme Court of India observe? And finally, what can be the implications of that particular judgment and the government's directive as well. So this governmental, before we actually go and understand what is this particular governmental directive, firstly we'll try to understand what is Kawar Yatra. Now, as we already witnessed in this previous picture, that I am very sure that you guys must have witnessed people walking through the roads carrying these elements, this particular structure which is containing the pitchers of water. This horizontal structure which people carry over their shoulders, in Hindi it is called Kawar, and the people who carry it are called Kawariya. So this Kawar festival is basically a festival or a pilgrimage which is performed by lakhs and lakhs of Hindu devotees to show their allegiance to Lord Shiva. And what they do is that in the month of, so with respect to the Kawar Yatra, it is a pilgrimage. It is a pilgrimage which is performed by lakhs and lakhs of Hindu devotees to show their devotion towards Lord Shiva. And what do they do in this thing? So as we already saw in the previous slide, that in the horizontal beam which every Kawariya is carrying, they are carrying pitchers of water. And from where they are picking up the water? From the river Ganges. So what do they do in this particular pilgrimage is that every devotee carry that Kawariya which is carrying the pitchers of water. So they collect the water from Ganges or river Ganga or any other river of that particular area, and ultimately this water which they have collected in these pitchers, they will go to the nearby temple of Lord Shiva, prominent temples of Lord Shiva. And while actually they are under this pilgrimage, most of these Kawadiyas are walking barefoot, and they are trying to cover a long distance of long distances with respect to collection of water for their pitchers, and ultimately for reaching the prominent Shiva temple or Shiva shrine, so that they can actually offer that water to the Lord Shiva. And for your better understanding, I have provided a schematic diagram or a map which usually is being followed by various Kawariyas with respect to the state of UP. So one of the most important areas of collection of water from the Ganges lies to the Gaumukh or Gangotri, or people actually collect water from Haridwar also, and then after collecting the water they walk towards the very prominent Shiva temple or a Shiva shrine, which can be any Jyotirling or any regional temple which that particular Kavariya feels that this particular temple is important for them. Now, what happens is that when these Kavariyas walk through hundreds and hundreds of kilometers, they go through different geographies, different habitations, and ultimately when you are walking through such long distances, there might be a requirement of various kind of lodging facilities, various kind of fooding facilities in terms of restaurants or dhabas, and certain kind of medical camps as well, because it might be a possibility that if Kavariyas are walking for hundreds and hundreds of kilometers, and that too bare feet, it might be a possibility that they might get injured or some kind of event might happen with them. And for these kind of things, for lodging, fooding, restaurants, medical camps, both government, civil society organizations and the private sector, they take care of such kind of things. And this forms one of the major boiling point with respect to the issuing of directive by the UP government. So what happened is that when Kavariyas take their water to the Shiva temple, they pass through various kind of townships and habitations, and ultimately there might be a possibility that it might lead to some kind of social tension or communal tensions when group of Kavariyas pass through a particular habitation which is inhabited by a particular community belonging to different religion, and this might lead to development or flaring up of communal tensions. And one more important thing which we need to observe over here is that while performing this particular pilgrimage, all the Kavariyas, they basically stick to a very pure vegetarian diet. So what happens is that whenever they are walking through the highways and whenever they go to some small restaurants or dhabas, they are not sure about whether the food is vegetarian or whether there are certain ingredients in the food which belongs to the non-vegetarian classification. And to do away with such kind of problems which are being faced by the Kavariyas while they are performing their pilgrimage, UP government came out with a very unique directive. And let us try to understand what was this particular directive. So under this directive, the Muzaffarnagar Police Department, they issued a directive. And what did the directive contain? They asked all the hotels and dhaba owners, dhaba is a Hindi term for smaller restaurants where people can eat, to display the name of their owners and employees in front of their restaurant or dhaba, and in bold and very large writings, so that before any Kavariya will enter that particular restaurant, that particular Kavariya will be able to know to whom that particular restaurant belongs to. However, and who are the what are the major names of the employees who are preparing the food within that particular restaurant. And this was the entire issue which was not well received by various kind of restaurant owners and their associations, because ultimately it is quite a troublesome tendency which has been shown by the UP Muzaffarnagar Police Department's directive, because they were trying to elicit the name of the people who are owning and the name of the employees also, which prima facie do not have any direct relationship with the quality of the food that they are offering. And that is why the Association of Restaurant Owners of Muzaffarnagar and nearby districts of Shamli, Saharanpur, etc., they went to the Supreme Court and challenged this particular directive by the name, and they claimed that this particular directive is providing for economic segregation, and ultimately these directive smells of a communal undertone. that ultimately with the help of this directive, government or that particular state government's department is trying to subjugate a particular religion or people belonging to particular religion who are owning those restaurants or dhabas. Now, this is a very troubling event which had happened in the state of UP. However, what did the government provide their justification? The government, they claimed in their directive that they wanted that the Kaveriya should be well informed about what kind of food like ingredients these people are using. But do you think that there is any relationship between the religion of a person and what kind of ingredients they are actually using in preparing any particular dish or any food item? And that lies the core issue within this particular topic. Now, what did the Supreme Court observe with respect to this particular directive which was appealed in the Supreme Court? So, the first thing Supreme Court observed was that ultimately all the facets or issues relating to the food safety do not come under the competent authority of police department. However, the competent authority to look into such issues will be the Food Safety and Standards Authority of India. Food Safety and Standards Authority of India. And this Food Safety of Standards Authority of India has a rule by the name of Packaging and Labeling. Packaging and Labeling Rules of 2011, in which it explicitly asks all the restaurant owners to be proactive in disclosing whether a food item is veg or non-veg. And Supreme Court commented that there is no point with respect to why a restaurant should be displaying the names of their owners and the employees which they have hired to prepare the food right in front of the restaurant, because ultimately that thing is not going to determine what kind of ingredients are they using in the food item or the overall quality of the food, which again has to be maintained by the Food Safety Standards Authority of India as well. The second point the Supreme Court noted is that this particular directive goes against the Article 19, Clause 1, Clause G, which provides the fundamental right of freedom to every citizen of our country to practice any business or profession without facing the discrimination based on religion. So ultimately this directive was going against the freedom to do business and trade. And thirdly, it also violated Article 15. And what does the Article 15 says? It prohibits that there should not be any discrimination. It prohibits discrimination based on religion of that particular person. So state cannot do any kind of discriminatory treatment or provide any preferential treatment to any other community on the behest of providing discrimination to some other religious group. So ultimately it went against the Article 15 of the Constitution as well. Ultimately, last point, the petitioners of this particular case, they also mentioned that this particular directive was also going against the Article 17, since in the directive the state government had asked all the restaurant owners to actually mention the name of their employees also who are creating the food. So it might also involve caste angle in who is going to prepare the food. Is the food which is being eaten by the Kavariyas is being prepared by some of the persons who are belonging to scheduled caste or lower caste? So ultimately it is providing a very subliminal undertone of the caste-based discrimination as well. And these were the major observations which were made by the Supreme Court of our country. Now, ultimately what we need to understand over here is that there is a term called dog whistle politics. Dog whistle politics. And what does this term stands for? Ultimately, this means this term comes from the term of dog whistle. So usually to train the dogs, there is a very peculiar and very unique whistle, that since we know that the dogs are capable to listen to such frequencies or wavelengths of the sound waves which are not quite audible to the human beings. And these whistle which are used for the dog training, they produce such sound frequencies which are not audible to the human beings, but they are audible to the dogs. And similarly, this formed the inspiration for this term called dog whistle politics, is that it is a form of communication of politics with respect to how government communicates their policies, where it seemed very harmless to the majoritarian group. However, it has certain very dominant undertone with respect to certain religious or social groups. And ultimately, with respect to such governmental directives which have been issued by the UP government, it might be a possibility that it might create the loosening of social fabric of our country, and it will also hinder economic cohesion within our society. And lastly, through such kind of policy directives, it will also create a suspicion where every social group will look into the other group with a sense of suspicion, and ultimately the trust present in the society will be gone and there will be less tolerance. And that is why this Supreme Court directive to hold the directives provided by the UP government is a very milestone in that respect. Okay, so now let's come to the next topic, which is Sampoornata Abhiyan. Now, this particular topic belongs to the topic of governance or the important governmental schemes which have been launched by the Government of India. And similarly, as the name suggests, Sampoornata, which means total development, stands for total development. So now let us try to go and understand what does this particular campaign stands for. So again, we are going to follow the same approach. Firstly, we will try to look at what is Sampoornata Abhiyan and what are its objectives. Secondly, we will try to correlate it with what are aspirational district program and what is aspirational block program. And thirdly, we will try to address what are the major focus areas of the Sampoornata Abhiyan. So we will begin with the first thing, which is what do we actually understand by the Sampoornata Abhiyan. So Sampoornata Abhiyan is a very recent campaign. It's a campaign which has been launched by the NITI Aayog to bolster developmental activities in 112 aspirational districts and 500 aspirational blocks. This is the core agenda with respect to the Sampoornata Abhiyan. Now, how does it want to achieve it? So, the Sampoornata Abhiyan, they want to achieve saturation in 6 important key performance indicators with respect to both aspiration districts and aspiration blocks. And what does these 6 KPIs belong to? They belong to 5 or 6 major sectors, which we will discuss in the coming section. However, this particular 6 KPIs, the full saturation of this 6 KPIs has to be done in 3-month period. And it has started from July and it will end till September. Now, to understand this particular Sampoornata Abhiyan is a campaign within the aspirational district program or the aspirational block program. So, to understand these 6 KPIs and what are these 6 KPIs which the Sampoornata Abhiyan tries to saturate it and to provide a very good impetus to the development which is being taken place in the aspirational districts or the aspirational blocks. Firstly, it will be better that if we will be able to understand what is this aspirational district program, and secondly, what is this aspirational block program. So now let us start with understanding the second point, which is what is aspirational district program. Now, as we know that the fruits of development is appropriated by different sections of the society in different way. It will be a possibility that certain sections of the society will be able to take benefit of the economic growth which is taking part in our country in a much better manner as compared to the socially and educationally backward classes. So similarly, so the fruits of development, it can be appropriated based on social classes, That is, the privileged classes will be able to take the benefits of the economic growth which is taking part in our country in a much better manner, and they will be able to participate in the economic growth and the story of India's economic development in a much better manner. Similarly, the fruits of development are also being appropriated in a regional manner. That is, it is not that the entire part of the country is experiencing the same rate of economic growth. There can be certain areas like Gujarat, which is Gujarat, Maharashtra, South Karnataka, which is facing very high growth rates. However, there can be some another part of India, like the eastern part of the India, which faces very low growth. And that is why the regional experience of the India's economic development is again quite fragmented. There are pockets of prosperity and there are also oceans of deprivations and low economic growth, poverty, underemployment, lack of skill development. And that is why NITI Aayog in the year of 2018, they came up with a very unique and innovative scheme by the name of Aspirational District Program. Under the program, almost 112 most poorer and weaker districts were chosen, and they were provided fund from the center and from the state governments and from the corporate social responsibility as well, so as to provide a lot of developmental impetus to such poorer and weaker districts. Now, if you can see this particular diagram, the districts which are put over here in the dark are the aspirational districts, and it is quite visible that majority of the aspirational districts, which comprise a group of districts which are very poor, backward and relatively isolated from the rest of the districts of our country, they are belonging to the most of the eastern part of our countries, or they are located in the very remotest part of our countries. For example, these districts, which is forming the border districts. And to provide for a more regional equity in the growth story of our country, to provide regional equity in the growth story or the developmental story of our country, this aspirational district program was launched by the NITI Aayog in the year of 2018. And this particular aspirational district program, they focused on or provided the thrust in three areas. The first was on convergence. Convergence of what? Convergence of both central and state resources, that is the funds. Secondly, it provided for the collaboration with respect to the central officers, state officers and district level officers, so that whatever has been planned in the center is being corroborated by the state and is being actually implemented by the district level officials. And thirdly, it provided a spirit of competition among the aspirational districts as well. And how did it promote the competition among the various 112 aspirational districts? By providing a monthly delta ranking. Monthly delta ranking, which is based on 49 KPIs, 49 performance indicators belonging to 5 broad categories. And what are these 5 broad categories? Very simple to remember. First is health and nutrition. Second, health and nutrition. Second is education. Third is agriculture. Fourth is skill development. And fifth, infrastructural development in those particular aspirational districts. Now, based on the performance of the districts in these broader 5 categories, monthly ranking has been provided in a portal called Champions of Change portal, which is again maintained by NITI Aayog itself. Champions of Change portal. So, with providing such monthly rankings among the various aspirational districts, the central government and the state governments are prodding or encouraging their districts to perform in a much better manner in these 5 categories, and ultimately involving and accentuating a sense of competition, so that ultimately they will provide better opportunities for the citizens of those districts to participate in the developmental story of that particular district. Now, similarly, what had happened is that by looking or getting inspired from the success of the aspirational district program in the year of 2023, again NITI Aayog and launched aspirational blocks program. Aspirational block program, where the same philosophy was being implemented but at the block level. Now, as we know that any district is comprising of various kind of blocks. So the core philosophy was same, that throughout the entire India, 500 most backward blocks were identified, and again these blocks were provided impetus with respect to saturation of these KPIs or performance indicators within these 5 broader categories. Now, as we know that the Sampoornata Abhiyan that we are trying to learn in this particular topic is just a campaign of this aspirational district program and the aspirational block program. And this Sampoornata program is trying to saturate 6 very important key performance indicators within these particular districts and blocks for the next coming 3 months. And what are those 6 important parameters? And these are the 6 important parameters which the Sampoornata Abhiyan is focusing across the aspirational blocks and the aspirational districts. So we will try to understand it one by one. So the firstly is percentage of pregnant women registered for antenatal care. Secondly, percentage of persons screened for diabetes, similarly for hypertension. This shows the government's focus on the non-communicable diseases. Thirdly, percentage of pregnant women taking supplementary nutrition. Soil health cards generated against soil sample collection target. And lastly, the percentage of SHGs that have received a revolving fund against the SHGs in that particular block. So this ultimately forms to the financial inclusion. These 2 forms for the nutrition and this forms for the agriculture. Similarly, the 6 identified KPIs or the key performance indicators for the aspirational districts are percentage of just like the same which we are having for the blocks. Going for the antenatal care, again it falls for under the broader category of nutrition. Second also forms for the broader category of nutrition, that is pregnant women taking supplementary nutrition under ICDS. Thirdly, percentage of children fully immunized 9 to 11 months for BCG, DPT3 and OPV3 and measles 1 vaccines. Number of soil health cards distributed, percentage of schools with functional electricity at the secondary level, and lastly, percentage of schools providing textbooks to children within 1 month of the start of the academic session. So ultimately, these are the major KPIs through which the Sampoornata Abhiyan is prodding, encouraging and pushing the various district administrations and the state government to fulfill these 6 performance indicators in the coming 3 months, which is ending in September. So this was all for this particular topic. Now let's come to the next topic, which is Right to Repair portal. Again, this is a very interesting topic and the topic's name is Right to Repair portal. So before we actually go and discuss what is this portal is all about, we need to understand first what do we actually understand by the term right to repair. So now let's start to learn this particular thing. So again, this is the structure that we are going to follow in this particular topic, that is what is right to repair, what is the need for such right to repair, what is the features which the government has provided within this particular portal, which is the right to repair portal, and what benefits can we actually expect from this particular portal. So now let us start with what do we actually understand by the term right to repair. So right to repair is nothing but a concept which allows the end users of what? Of any product. Now these end users can be a consumer or an individual consumer, or it can be a business owner as well. It can be a business or an institute. So if any individual or an institute is using any product which has been manufactured by any proper company or original equipment manufacturer, so this right to repair it entails a concept where an end user will be able to repair any equipment or product without facing any intervention from the original manufacturer or without facing any issue of hindrance of right information with respect to how they have to repair it. That is, ultimately, whether be it individuals or institutes, they should not be dependent on the original equipment manufacturer, or there should not be any dearth of information with respect to how these individuals or institutions can actually repair any particular product through their own self or through any third party service providers. And what is the need for such portal? So to understand the need, it is very important that firstly, it is there, the most important need is to combat designed obsolescence. The key word over here is designed obsolescence, which is, now as you will also understand and relate, that whatever electronic equipments that we are purchasing nowadays, they have got a very smaller shelf life. The product equipments or the micro equipments that the manufacturers are using, they have been designed in such a way that they will get worn out in a very smaller span of time. And ultimately, it has been told in various literature reviews as well, that ultimately all the companies are using such kind of components which will not last long, and ultimately it will not provide the consumers or the end users to get it repaired, and they have to throw it away and purchase again another electronic equipment. So ultimately, to combat the designed obsolescence, this right to repair is a very important concept and as a movement. And secondly, to break the monopoly of manufacturers in providing services. This also you must have observed and experienced in your own life as well, that whenever we are trying to purchase any particular phone, it will be a possibility that if anything goes wrong with that particular electronic equipment, say phone in this case, we will be bound to go to that particular manufacturer to which that particular phone belongs to. And that is where comes the information monopoly, that ultimately the consumer is dependent on that particular company itself to get their phone repaired. And it is very easy for the companies, whenever you will go to the companies and you will tell them that, okay, my phone broke, kindly repair it. It is very easy for them, since these things are quite technical, they will be very easily able to tell you that this phone cannot be repaired and you have to purchase a new phone. So ultimately there has to be much more information present with the consumers of those particular products, so that the consumers themselves, they will be able to understand whether this product needs replacement or whether this product needs repair. So ultimately, through information, through proper legitimate information, consumers will be able to discern between replacing the product or purchasing a new product versus whether they should get it repaired. And fourth important aspect which we need to understand over here is that since the entire globe is facing a lot of e-wastage problem, and with the help of such kind of portals which promotes usage of such electrical and electronic equipments after repairing, it will lead to better management of e-waste. That is, it will actually promote the 5R principle, that is reduce, refuse, reuse, repurpose, and then finally recycle. So this was the prime core need which was required for the establishment of right to repair portal. Now the next thing is, what are the various features associated with this particular portal? So we'll try to understand this thing with this particular images. So ultimately this portal is that every company belonging to these four sectors, that is the farming equipment sector, mobiles and electronics, consumer durables, which involves refrigerators, washing machines, microwaves, etc., and automobile equipments, whichever company is falling under these broader categories, if they are like selling their products or equipments in our country, they are bound to get themselves registered in the right to repair portal. So it is mandatory for companies to get themselves registered. Now post registration, what they should be doing is that this portal is going to bring out all the information at one place. So portal is functioning as a single window interface to provide information about what? Information about various kind of technical utilities which the various companies are using in their proper electronic equipments, so that the consumers will be aware about what kind of technicalities are present within the phones or tablets or any other electronic equipment which they are using. Secondly, this single window interface will also contain all the contact details with respect to the customer care services. Also, it will also provide a single window interface with respect to third party service providers. What do we mean by third party service providers? Suppose, for example, if you bought a phone of iPhone, so you should have the right to get it repaired not only from the Apple company but also from some other very well qualified third party service providers, so that it will lead to a better choice or autonomy in front of the consumers as well. So ultimately, these are the kind of companies, this is just for an example point of view, that these are the companies which are already registered in the right to repair portal with respect to our country. Now, last important point is that what are the benefits associated with this particular right to repair portal. So the first point is, ultimately it will ease our burden of the e-waste, since entire world is getting dumped with tons and tons of e-waste because of the increased consumption of electronic equipments in our day-to-day lives. And secondly, it will save a lot of consumers money as well, because we will not be throwing away our electronic equipments just because it has broken down. We will get it repaired and we will reuse it. Thirdly, it will help India achieve its goal in the SDG, or the Sustainable Goal 12, which stands for sustainable consumption and production. In my view, SDG 12 is one of the most underrated sustainable development goal which the world or the global community has to achieve, because ultimately it tries to address the consumption part of the economic ecosystem. So it is not trying to regulate it, it is trying to tell the global citizens that ultimately we need to understand that we need to develop such kind of lifestyle and such kind of lifestyle choices where our economic decisions are not creating further burden on the global ecological balances. And that is why India will be able to achieve its SDG 12, that is sustainable consumption, with the help of this right to repair portal, because it will encourage more and more customers and the companies also to provide for such kind of facilitative arrangement where people will go for repairing of their projects rather than throwing away such products and purchasing new ones. And lastly, it will help in our mission life, that is lifestyle for environment. Mission life, lifestyle for environment. So this was all about the right to repair portal. Now let us come to the next topic, which is defamation case against Wikipedia. So this is again a very, very important topic from fundamental rights point of view and from a very constitutional point of view. So now let us try to understand the core background of this case. Now, as it is quite visible from this picture itself, that there has been a defamation case against Wikipedia, and this defamation case has been filed by a news media agency by the name of ANI. And what the ANI had suggested is that in the Wikipedia page of this ANI news media agency, it contended that, the ANI contended that the Wikipedia page is containing very false and defamatory information. Defamatory information about the ANI as a news agency. And why did the ANI agency said so? Because in that particular Wikipedia page, certain informations were written about ANI which claimed that ANI was very pro-government. It provides illicit information or malicious information, and it promotes misinformation among the people. And because of these information which was present in the Wikipedia page of the ANI news agency, it urged the media agency and it approached the Supreme Court of our country, filing a defamation suit against the Wikipedia, and it claimed almost rupees 2 crores in damages from the Wikipedia. And this was the entire background with respect to this particular case. Now let us try to understand this case also in detail. So was this the defamation case which was filed against the against the Wikipedia is new? So similar thing, very interesting thing had happened in the year of 2022 as well. Now if you remember this dropped catch by Arshdeep Singh, our very prominent fast bowler. So in the Asia Cup final, when India was playing final against the Pakistan, Arshdeep had dropped a very important and a crucial catch. And ultimately, because of the dropping of that particular catch, India lost that particular final to Pakistan, and definitely it irked our very famous cricket captain Rohit Sharma as well. And what had happened after that is that it fumed the entire citizen of our country, and the users of the Wikipedia also changed very prominent details of Arshdeep Singh Dhillon in his page in Wikipedia. So the entire page which belonged to Arshdeep, it got filled with very malicious information which was not correct, false and defamatory. So whatever has happened in this particular case is not unique, and it has happened with very prominent figures as well, that whenever a cricketer not performs well, there might be a tendency that their information or the information about them in the Wikipedia might change. So to understand the core nuances of this case, we need to understand how does the Wikipedia actually functions, and who are those people who can actually change, edit or add or fact check the information which has been provided in Wikipedia. So now let us try to understand what is Wikipedia and how does it actually work. So Wikipedia is a very revolutionary tool. It's a very revolutionary tool. Why? Because ultimately it is trying to bring the entire human knowledge to everybody who is on the internet in a free and extremely accessible manner. So Wikipedia is on a mission to democratize the human knowledge that everybody, every individual, whether they are rich, poor, whether they are sitting in India, US, Libya, China, they should be able to access the human knowledge, because knowledge is a repository of human as a civilizational product and not of a particular country or a social group. So it is going to democratize the human knowledge, and it is going to make it available and accessible to every citizen of the world, or to every people who is there on the planet Earth. Now, how does the Wikipedia actually works? This is the about of Wikipedia. Now, how does it work? So ultimately, for every topic, Wikipedia, say if there is a page for any particular topic, the pool of users, the users who are registered in the Wikipedia, they can add, edit, update and fact check any info about this particular topic. And similarly, because Wikipedia in its zealous motive to democratize the human knowledge, it is also having certain kind of policy and user usage policies, and based on those policies, Wikipedia also has a group of its reviewers. Wikipedia also has its way of reviewers. So whenever user are trying to add, edit, update or any fact check any information which is present for any particular topic, say A and I for this case, so the users who are using the Wikipedia platform, they are able to change the information, and this change will be monitored by the reviewers of the Wikipedia as a community as well. And ultimately it will be the reviewers who will finalize whether this particular information about a particular topic is correct or not. One important thing which we need to note over here is that while the users are providing information about a particular topic, the reviewers have to make sure that whatever info has been there, it should be very neutral, it should be credible and well sourced, that there has to be credible source which is corroborating this particular fact which has been written in that particular topic. And ultimately when the reviewers give a final nod, this particular information is available to all the users of Wikipedia. And this is the entire procedure which is being followed. Now, what does the law says with respect to it? Now, important thing, the important legal questions which we need to understand over here is that two important key terms which we need to understand over here. And the important law which is regulating this thing is the IT Act or the Information Technology Act of 2000. And two important keywords which we need to understand over here, which is social media intermediary, and secondly is the safe harbor clause. Safe harbor clause. Now, what is social media intermediary? So the section 2 clause 1 of this particular act provides for the definition of a social media intermediary. And what is a social media intermediary? Social media intermediary is an entity which links two different parties, party 1 and party 2. And what role is being provided by the social media entity or this social media intermediary? It is collecting, processing and storing and ultimately transmitting information from one party to the other party, and this can be one to many as well. And what can be these entities? These entities can be internet service providers, network service providers, etc. Some of the prominent social media intermediaries, you guys are every day you are spending a lot of time on this thing, and by this channel also that you are able to watch recitals in depth through the medium of YouTube. So the prominent social media intermediaries are YouTube, Facebook, Instagram, Twitter, etc. So these are the prominent examples of social media intermediaries whose definition is provided under the section 2 of the IT Act 2000. However, why this particular definition is important is that for whatever this particular content creator is making, that is the number 1, this social media intermediary is not responsible for the content this particular number 1 person is generating. Why? Because this entity is only involved in collection, processing and communication or transmission of information from one person to another. So, if this person is flouting any legal norms of our country while creating any content, YouTube cannot be held liable for the malicious content which this person has created. But there is a catch in this thing, which is the safe harbor clause, which has been provided by the section 79 of the IT Act of 2000. And what does this say? By the term safe harbor, which means that the government of India is providing safe harbor to the social media intermediaries till an extent that this social media intermediary is following the legal directives given to them by the government, and secondly, the social media intermediary is not complicit with the content creator, or it is not creating a scheme to provide a loophole to the government's legal directives as well. So if the social media intermediary is following all the governmental legislations or directives in its own spirit and letter, then ultimately it will be provided a safe harbor. So the YouTube or any other social media intermediary will not face any legal backlash or any administrative backlash by the government of India if the content which is being transmitted is malicious and unlawful. However, if the governmental agencies finds that even after, despite telling the various social media intermediaries to not to provide route to transmit such kind of malicious information, and if the social media intermediary is not listening to the government, in that case it might be a possibility that government will be able to take out the safe harbor clause with respect to the section 79 of the IT Act. And this is what has been the core of the core legal issue present over here. However, since this case belongs to the defamation area, we need to understand what has been the previous or earlier Supreme Court observations with respect to defamations with respect to the Wikipedia. So only one important case we will be able to get to a good conclusion over here is that there was a case or a defamation petition which was filed by the producers of Ayurvedic Medicines Association, which claimed that, again, just like in the previous case that we had noted, that the Wikipedia page about them, it contained very malicious, false and defamatory information about them. And Supreme Court, after having gone through their particular petition, it had told that the Wikipedia should be editing that particular page, since the review work which had been done by the reviewer group of the Wikipedia was not very legitimate and accurate, and the information which was provided by the users, which provided for false claims about this Ayurvedic medicine producers, were incorrect, and the Supreme Court of our country allowed the users to change it, and update the information about that particular party to the dispute. And this was all about this particular topic. I hope like the major important legal keywords that we had to understand, you have kept in mind. So the next topic for our discussion is Karnataka's domicile quota in jobs bill. Now this is a very, very important topic, because whether be it in prelims or in mains, reservation has been a very important issue, because over an years UPSC has been asking a question either in the mains or in the prelims. So now let us try to understand what is this issue all about. So recently, so again the structure of our discussion will be, we'll try to understand the context. Secondly, we'll try to see the various provisions of the bill. Thirdly, we'll try to see what have been the similar laws in this area. Fourthly, we'll try to identify and deconstruct the various constitutional and legal issues with respect to providing reservation to the local candidates or domiciled candidates. And fifth point, we will try to understand why there is a like increasing tendency where state governments are creating more and more such legislations. And lastly, what can be the implications of such kind of legislations. So now let us start with the context. So recently the Karnataka government, they approved, Karnataka government came out with a legislation which provided for local reservation. There are two elements to it. It provided for local reservation, first thing, that is reservation to people or the Kannadigas, the people who are local to Karnataka. And secondly, it provided for reservation in private employment. So that was the core of the core issue with respect to the bill which was provided by the Karnataka government. And as soon as the Karnataka government tabled the bill, it was received with huge uproar by the industrial representatives and the business representatives. And what did the government do? It withdrew the bill. So ultimately, the government, the protest by various industrial bodies and lobbies, it led to government to withdraw the bill. However, what we need to understand is that the broader issue, that why the government is providing local reservation or the reservation to the Kannadigas or the people who are the natives to Karnataka, and secondly, is the government entitled to provide employment in the private realm? Since we know that our constitution provides the government or the parliament to provide reservation in public employment, but can the government provide reservation in the private employment as well? And this is what we are going to deconstruct in this particular topic. So now let us start with the provisions of the bill. So the name of the bill was quite long, that is Karnataka State Employment of Local Candidates. From the examination point of view, you don't have to mug up the name of the bill because it is quite long. Karnataka State Employment of Local Candidates in Industries, Factories and Establishment. Establishment Bill of 2024. And what does this provide for? What were the major provisions? Its intent we already saw, intent was to provide for reservation to local candidates. And what were the provision? It provided for 50% of reservation for managerial positions, and it provided for 75% reservation for non-managerial positions. And to whom it had provided? To the locals, and it had provided a definition of local candidates as well. And how did it define the local candidates? It defined the local candidates with 3 points, that is person born in Karnataka, domiciled in Karnataka for last 15 years, and thirdly, a person should be proficient in the Kannadiga language as well. That is, person should be able to read, write and speak the Kannada language. Now, if a person is meeting these 3 criterion, then only that person will be labeled as a local candidate, and then these local candidates will be able to have their own share of their own pie for the reservation in the private sector employments. Mind it provided for the local participation in the private sector employment. And ultimately, very logically, as we can actually infer, that this particular bill, because of its provisions for the reservation of almost 75% of the vacancies which are there in the private sector, it was not at all received well by the industry bodies and the industrial owners. And since Karnataka is one of the most important hotspot for the startup ecosystem in our country, that is Bangalore, ultimately it led to a lot of backlash and the government had to withdraw it. So these were the major provisions with respect to it. Now we also need to understand one more thing, that are there any other states which have come up with similar kind of legislations? So the answer is very yes. And what are these other states? Answer is yes. What are these other states? Andhra Pradesh, Haryana, Madhya Pradesh and Jharkhand. So these are the states who have set another precedent of coming up with similar kind of legislations, providing definitions of local candidates and providing reservations for the local candidates in the private sector employment. To name some, similarly is that we have Andhra Pradesh Employment of Local Candidates Bill of 2019, which was passed ultimately, but the government could not implement it. Why? Because there were again huge backlash by the industrial body. And similarly, Haryana State Employment of Local Candidate in Shops, Industries, etc. Act of 2020. So it gone through the same fate, however the fate was bit different. The Punjab and Haryana High Court, it struck down this particular act of Haryana government because of certain legal issues which it had contained. And what were those legal issues? This is what we are going to discuss in the constitutional and legal issues. Now, the whole part is, we know that under Article 14, 15 and 16, the constitution of our country provides the parliament and the state legislatures the power to provide positive affirmation to certain social groups of our society, that is which are explicitly mentioned in the constitution are scheduled caste, scheduled tribe, socially and economically backward classes, and after the 103rd amendment of the constitution of our country, the economically weaker sections. Now these are the prominent explicit social groups which the constitution empowers to have reservation in public employment and in the admission of educational institutions. However, one important thing we need to note over here is that under Article 14, the first important legal issue it faces is from the Article 14. That is, by providing reservation to the local candidates or the domiciled candidates of any particular state, it goes against the doctrine of reasonable classification. Doctrine of reasonable classification. What do we mean by that? As we know that the Article 14 stands for equality before law and equal protection of law. So the constitution or the parliament has to make sure that the parliament is making laws for certain those sections which are very, very marginalized in our society, like SC, ST, socially economically backward classes and the economically weaker sections. So the parliament or the state governments can come up with certain laws to provide for reservations for these category of people. However, if we are creating one more classification based on domicile, it does not go with the doctrine of reasonable classification and it defeats the purpose of Article 14, that is the equal protection of law. Second important point which we need to note over here comes from Article 15. Article 15, it categorically prohibits the state to do any kind of discrimination based on place of birth. It is very explicitly written over there. So again, this particular bill of Andhra Pradesh or the act which was struck down by Punjab and Haryana High Court or the act of Haryana government, they basically played foul with respect to Article 15 of the constitution, and this is what was the argument which was noted by the Punjab and Haryana High Court, that it basically violates the Article 15 of our constitution. The third important point which we need to note over here is the Article 19 Clause 1 Subclause G. And what does it provide? It provides the right to freedom to practice any trade, profession and business. Trade, profession and business, and by the governmental agency, by providing reservation in the private sector private sector employment opportunities, what the government is trying to do is that it is trying to violate the fundamental rights of the individuals which has been provided to them by the Article 19, Clause 1, Clause G of the Constitution of India. And these are the major important legal and constitutional issues which actually creates a lot of trouble for such kind of legislative agendas or legislative tools which are brought forward by various state governments, as we had noted earlier. Now, similarly, we need to note that the legal issues and the constitutional issues that we readily witnessed, that was fine, but we need to actually diagnose the larger or the deeper problem, that why is it that the states are again and again coming up with similar kind of legislations? Why they can't focus on more infrastructural development, more opportunities for job growth, more for infrastructural or industrial development, but why is it that the state governments are creating more and more legislations for such kind of things? So for that, we need to understand the more deeper issue of very structural unemployment and underemployment in our country. Now, there is a very important organization by the name of Center for Monitoring of Indian Economy. What it does is that it tries to gather data with respect to the employment of our country, and it has painted a very dismal picture for India. Now, the unemployment rate for our country is roughly 12%, which is very, very high. And apart from that, having this much high unemployment rate, the labor force participation rate of our country stands at abysmally low of 39.5%, which is very, very low. And this shows that the problem of unemployment and underemployment in our country is extremely chronic, and the state governments are not able to provide a holistic solution to it. And what is a very politically viable solution for such state governments is to provide reservation to their locals. Why? Because ultimately it is politically very beneficial that whoever is the political party who is trying to get these reservations to the local candidates, they will be able to garner more and more votes based on this parochial and very narrow policy agenda. And this is what we had to actually understand it over here. Okay. And lastly, what we need to understand is what are the major implications of bringing in such kind of legislations. So the first point it does is that it hampers the economic freedom. That is, the industrial bodies or the startup founders who have risked a lot with respect to investing their funds or hard-earned funds to develop industries and startups, they will not be able to actually identify the policy direction which the government is going to take, and accordingly businesses are not flourished in such a policy insensitive environment, and ultimately it reduces the economic freedom present with the various kind of industrial bodies and the startup founders, since it is also promoting state intervention in the business affairs. The second point is that it hinders economic integration. Now, since the states will be providing reservations to their own domiciled residents, it will create a very prominent hurdle for the economic integration of our country as a whole. Now, India is an extremely moving country. Migration is taking place from one part of the country to another. And if there is a reservation, it will create a very silos-led development in our country, that every state will face a severe shortage of supply of well-skilled laborers as well, which will dampen the spirit of economic integration. Thirdly, with such kind of uncertain policy environment, it is not good for the ease of doing business of our country as well, and it might be a possibility that majority of the FDIs might take out their money from our country because of such uncertain policy environment. And lastly, it will create a very negative impression for migration, which is not good for our social cohesion. Now, since any economic opportunity or employment opportunity by any state government will be available only to the domiciled residents of that particular state, it will create a very negative impression with respect to the migrant laborers who have come to the state, and they will looked out with a sense of suspicion, which will again diminish the social cohesion which is present in our society. And ultimately, all the economic activities and the political processes which goes on, it needs a very viable social fabric or a social base. And if there is lack of trust or there is more and more suspicion within the society, all the economic activities are bound to crumble in medium to long term. So this was all with respect to this particular topic. I hope you understood the core of the core constitutional and legal issues and the implications which such kind of legislation has. Okay. Now let's come to the next topic. So the next topic of our discussion is Neurorights. And believe me students, I feel that this is one of the most interesting and important topic which we are discussing for this month's edition. So by the term Neurorights, as we understand that the term neuro belongs to the brain or the mind, and the rights. Rights, as we know, are the claims we have on the states or any other particular person. So what do we understand by the term Neurorights? As we already know that we have certain fundamental rights, we have human rights, we have right to privacy, that is to protect our data from the interference or from the surveillance of the state or any other particular private sector agency. However, what do we understand by the Neurorights? By the term itself, it means that the right which an individual should have to protect their own thoughts, their memories, and their mental states, moods, mental preferences, so on and so forth. And why we are discussing it? Because ultimately there have been a lot of advancement in the field of neurotechnologies. Neurotechnologies are those technologies which studies the operations of human mind and brain as a whole unit. So now let us try to understand it in quite detail, and we will be discussing with very important examples from the world of technology, so as to help you, make you understand this topic in a much more better manner. Okay, so again the structure will be same. Firstly, we'll learn about the need for neurorights. Secondly, we'll see what are neurorights. After that, we'll go for status of neurorights in the world and existing legislations for the protection of neurorights in our own country, that is India. So what do we firstly, let's start with the need for neurorights. Now, as you already know that we are surrounded by various kind of electronic equipments which we are interacting day in and day out, and there has been a great advancement in the field of neurotechnologies. And we, as we already noted, that what are these neurotechnologies? Neurotechnologies are those technologies which either observe, interact, and to a certain degree alter what? Our mental states or mental processes. And what does this mental states or processes combine of? Our thoughts, our memories, our inherent choices, etc. And these neurological technologies have been developing since a long time. For example, to name some, if you know, you must have heard of the term of EEG, short form for electroencephalography. Similarly, MRI, that is the magnetic resonance imaging. And lastly, the third most important is the brain-machine interface. Brain-machine interface. Now, these neurotechnologies which are trying to observe, monitor our cognitive activities which are going on around in our brain, and all the activities which are going around in our brain are very prominently described by various neurobiologists as electrical activity, electrochemical activity. Electrochemical activity. And you will be surprised to know that majority of the neurobiologists, how do they term our brain? They define our brain as wet computer. Wet because ultimately it comprises of the grey matter and all the electrical and chemical reactions are taking place, which is resulting into flow of electrons, which is creating its own magnetic and electric field of our brain, which these technologies will be able to monitor, and they will be able to decipher the meaning or the broader information which is actually present in our electrical activity which is present in our brains. Now, one of the most important forms of neurotechnological solutions which are present with humanity right now are the brain-machine interfaces. Now, whenever these technologies started to begin, it was non-invasive in nature. That is, ultimately, all the machines like EEG and MRI, they were external to the human beings. However, with more advancements of the neurotechnologies, there are emerging in our horizon, which is called as brain-machine interface. And the prominent front runner in this case also is again a company by the name of Neuralink. And who is owning this company? Elon Musk. Yes, the same Elon Musk who owns Tesla or the SpaceX. So we can see how futuristic Elon Musk as a person itself he is. Okay. So what Neuralink is trying to do, that they have created this particular link. Okay. This smaller chip looking, a very small coin size chip, and this chip has been implanted in the spinal cord or the spine of a monkey, which you can see over here. And now let me take you through a very smaller experiment and yet a very intuitive and interesting experiment what this Neuralink has already committed, and these people have gotten success also with respect to it. Now let's come to this particular thing, that what this Neuralink is trying to do. So what Neuralink did is that they have tried to implant this chip by the name of link near the almost near the end of the spine, where the neck is ending and the spine has ended, or the joint of the spine and the neck. So they have put their neural link or the link over there, and these links are being connected with the neurons or the group of neurons which are present over there. And this monkey was trained to play this game earlier with the help of a joystick. And whenever the monkey used to win in that particular game, this nozzle, if you can see, through this nozzle they are providing them with juice. So definitely monkey would want more and more juice, and to get more and more juice, monkey would be wanting to win the game. And earlier the monkey was playing the game with the help of a joystick. And what this particular link chip did is that whenever monkey was using his hands, so because of the usage of the hands, certain kind of electrical like points will develop in the brain, and this particular link was actually trying to capture those electrical generations in the brain of the monkey, and ultimately it correlated the electrical activity with the physical activity. So there was certain electrical activity within the brain for every physical activity the monkey did. And what this particular chip did is that it tried to encode and remember that whenever there will be a certain kind of physical activity, there will be a similar kind of electrical activity in the brain as well. Now just reverse the situation. Now what happened is that the scientists removed the cord which connected the joystick or the remote controller which was available to the monkey. And what had happened is that even when the monkey was not using the joystick, the monkey was able to use this link to move these elements in the game. So, and how the monkey was able to do it? With the help of the link, because link, this particular link or the chip, it basically decoded what kind of electrical activity will take place in our brain for a particular kind of motor activity or a physical activity. And this is the kind of potential does this particular technology holds with it, that ultimately with the help of a chip itself, the monkey is able to move the cursor on the screen without even touching anything. And that is the power of the kind of neural technologies or the power of brain machine interfaces which various kind of companies are developing. However exciting or the opportunities which these technologies might hold up for the humanity, but as of now there are more threats also with respect to it. And what are these threats? These threats can be, let us try to understand it from a help of an example. Say for example, this is a human being. Now whatever the human being is witnessing, suppose there is a stimulus. This is a stimulus. And this human being has been transplanted with a link or this particular chip. Now as this human is witnessing any kind of stimulus, some kind of electrical activity will take place in the brain, and this electrical activity can correspond to any thoughts, memories, emotions, moods, or their overall state of mind. And this electrical activity will be decoded by this particular link, which will be connected to a server or a large server or a large data aggregator. Data aggregator which can be owned both by the government or any private individual company which is actually operating that particular technology. So the government can also use this technology, and the data which is being generated, which is called the neural data. So this neural data holds significant value for both the government and the private parties. Why? Because through the digitization of our thoughts, memories, emotions, moods, and whatever, however we are seeing or perceiving through our eyes, and what kind of electrical activity it will create in our head, it will get codified in the form of binary bits or for the transmission or understanding of the computers. And these data will be utilized by the government and private sector for whether it can be for the benefit of the society or for the humanity as a whole, but they can be also used in a very malicious and malevolent way. And what can be it? So it can go for neuromarketing. So neuromarketing is a kind of marketing where different businesses are trying to alter your thoughts so that you will alter your economic decisions or economic choices in favor of a particular product by that particular company. Secondly, they will be able to use this data to alter your sense of identity. And similarly, with the help of this chip or neural data, any state or private entity, they can access the memory. And ultimately, these kind of activities, it provides a grave threat to the right to privacy and ultimately the sense of self or being human. And these are the major threats which are being posed by such kind of revolutionary technologies which are being developed by various companies of our world. And that is why we need certain kind of rights, certain kinds of rights which will protect our right to think freely, our right to think freely, and ultimately it will protect our mental states, that is our thoughts, memories, emotions, from any kind of external manipulation or alteration. That is the core requirement or the definition of a Neurorights. Now there are 5 different types of Neurorights which have been identified. Let us try to see it. So the first is, that is a personal identity, that under no circumstances the neurotechnology should alter, as we already noticed, that it should not alter the sense of self, that there should be a feeling that ultimately we are human beings. A chip should not be able to induce thoughts in our mind, and the subsequent actions should be determined by that particular thought. in that case we will ultimately lose our personal identity and sense of self, or the experience of having born as a human. The second is the free will, that is the ability to think freely. Neurorights should be there so that no neurotechnology should be able to inhibit or alter our ability to think freely. It should be, since we are born as a human, we should be able to think freely. Thirdly, the mental privacy, that is no technology should be able to go into deeper into our memories so as to reveal all the kind of information which we do not want to reveal it to the society. The fourth is protection against any kind of biases, that individuals may not be discriminated against based on their neurological data that they are catering. And lastly, there will be certain kind of neural technologies which will enhance the human being's cognitive capacities. And if those cognitive capacities are being advanced, such kind of technology should be easily accessible to every human being. Or ultimately what it will lead to, that only certain sections of the society will be able to reap the benefits of such technologies, and majority of the section of the society will be left behind. So again, the emergence of such technologies will create one more layer of stratification, one more pillar of discrimination, and that is why the Neurorights should try to address all these 5 concerns. Okay, now let us try to understand what is the status of Neurorights across the world. So you will be surprised to know that Chile is the first country which gave constitutional recognition to the neural rights to its citizens. Secondly, the 2 states of United States of America, that is Colorado and California, had enacted their own legislations protecting the neural rights of the citizens. And thirdly, UNESCO has formed a committee which will come up with a global framework for the ethics related to neurotechnologies, and this will in depth deal with the regime of the neurorights as well. And what is the situation of neurorights or the legal position in India? So as of now, since India is a very developing country, and as a developing country we are striving to actually protect the fundamental rights of the country. So to provide a very comprehensive and very technologically efficient legal regime so as to protect the neuro rights of our citizens is quite bleak. However, there are certain existent legislations which we will be able to protect the neuro rights of our citizens. So firstly, the first act is Information Technology Act of 2000, which provides for data protection as well, data protection and privacy. And this particular act and its provisions can be further expanded to control the neural data as well. That is the data which has been of our mental activity which has been digitized. The second is the Personal Data Protection Act of 2023. So this again provides for a very important clause, that is the personal data. It provides a definition for the personal data, and through various amendments to this legislation, the definition of the personal data can be expanded to include the neural data also under its ambit. And through the PDPA Act of 2023, it provides that all the personal data can be processed only after proper consent from the user. So personal data can only be processed only after the consent of the user. Apart from it, there are two important judicial decisions which we have to note. Firstly, the Selvi versus State of Karnataka, which happened in the year of 2010. And secondly, the most important judgment on privacy, that is the Puttaswamy judgment. Puttaswamy judgment of 2016. And what does these two judgments noted? It provided that we will start with the first judgment, that is the Selvi versus State of Karnataka. Selvi judgment was very fundamental and phenomenal with respect to the usage of intrusive methods which were deployed by the states. For example, polygraph test or narco analysis, so that what it noted is that such intrusion of technologies to get to the mental processes of an accused is absolute violation of right to privacy and their personal liberty under Article 21. And similarly, in the Puttaswamy judgment also, it was already noted that under Article 21, right to privacy is inherently protected, and liberty of an individual is only protected if the information of that particular individual or the right to privacy is protected for that particular individual. So these are the major legal positions and judicial pronouncements which are there in our country, which will be able to restore the balance with respect to the changing rapidly changing technological landscape with respect to the neurotechnologies, and how these neurotechnologies are going to impact the neural rights of our citizens of our country. So now let's come to the next topic, which is again a very interesting topic, which is there has been a very prominent scuffle between our Lok Sabha Speaker Mr. Om Birla and our very important leader of our opposition, which is Rahul Gandhi. So all this issue started with a very minor issue. Ultimately, it snowballed into a controversy. So what was this particular issue? So Rahul Gandhi had been accusing Om Birla that Mr. Om Birla has been switching off the mic of Rahul Gandhi, and not only Rahul Gandhi but also the colleagues of his own party whenever they want to speak on very important topic. So now let us try to understand this topic in its own entirety. So before we go on and discuss like the various kind of issues with respect to how the mics are operated in the parliament of our country, firstly briefly we'll try to understand what is the role of a parliament and what are the functions of a presiding officer. Now, as we know that the role of a parliament is the topmost forum for 3D, that is short form for debate, discussion and deliberation. And 3D should be done on what? 3D should be done on the most important issues facing the public interest or any legislations which the parliament has to make. And on this regard, so that the parliament can perform its constitutional obligation of being a forum or the topmost forum to provide debate, discussion, deliberation, to make sure that it happens in the most efficient manner, that is why speaker plays a very pivotal role, or any presiding officer plays a very pivotal role. By doing what? By deciding the agenda of the house, like what should be discussed in that particular house, in what order it has to be discussed, okay, what bills has to go for scrutiny, and ultimately to maintain the decorum in the house, so that all the participant members of the parliament or any legislative assembly for that instance, they should be able to express their point of view and they should be able to express their constituency and the interest of their constituency. However, what had happened here in this particular case is that Mr. Rahul Gandhi had accused our speaker Om Birla of playing a partisan role with respect to not providing him with proper time to speak, and secondly switching off his mic whenever he rose to speak on any particular issue. So although this issue seems very frivolous, however it holds very important information from our examination point of view. So the first point which we need to cover over here is that who controls and administers the microphone which are present in the parliament of our country. Now, Lok Sabha Secretariat in the year of 2014, it released a manual, and it basically, this manual contains all the information with respect to how does these microphones operate, who operates it, and till what time does these microphones actually provide or provide the opportunity for any member of the parliament to speak. Now, what does this particular manual say? It says that every seat in the parliament is numbered like 1, 2, 3, 4, 5, and every MP has to sit in their particular designated spot. Now, every seat which has been numbered has its own exclusive microphone, mic for short, And this microphone has a panel to it, which has various indicators or buttons associated with it. Two major buttons which we need to maintain over here are very important. One is a grey button, and one is a red light. Now this grey button has got its utility, which is that whenever a member of a parliament wants to speak, so what he does is that he will has to raise his hand pointing towards the speaker and ask for the speaker's permission to let him speak on a particular matter. And while they are raising their hands in front of the speaker to let them speak, they have to press this grey button. So this grey button is to ask for permission. So that whenever the speaker, suppose speaker is sitting over here, so and if any member one wants to say speak on a particular issue, member one will raise their hand and will press the grey button. As soon as speaker will see it, speaker will allow that particular speaker or the member of parliament to speak on that particular issue, so that this red light will start glowing. That is, the mic of that particular MP has been activated. However, one thing we need to note over here is that it is not the speaker who is controlling the arrangement of the microphone. However, there are a pool of sound technicians which are present in the parliament. And these sound technicians are based in a room which is called as chamber. And chamber is comprised of a glass wall through which speaker can see what is happening in the chamber, and the sound technicians which are positioned in the chamber, they are also able to see what discussion is going on around in the house of the parliament as well. So as soon as the speaker tells them that okay, that the MP number 1 can speak, the sound technicians who are sitting in the chamber, they automatically activate the microphone which is available with respect to that particular MP. And as soon as this particular time allotted to that particular MP is finished, this microphone is automatically switched off, which is again taken care of by the sound technicians. However, one important point which we need to note over here is that the sound technicians do not work on their whims and fancies. They can like switch on or switch off the microphone of a particular MP only on the direction of speaker, and they cannot function on their own whims and fancies, and that is what which we need to understand. So, and according to the same manual, there are few more important things which we need to note over here, that during zero sessions, whenever an MP is speaking, their mic is on for 3 minutes for any, and as soon as the 3 minutes are done, the mic will automatically get switched off. Secondly, for discussion on various legislations, every party has been allotted time. So every party has been allotted time, and the members of those parties will get their own proportionate time. And as soon as the time of that party which has been allotted is over, the mics will get off. And thirdly, if there are any special mentions, time is allotted by the speaker for 250 words. However, speaker on its own discretion, they can allow a member of a parliament to speak for 2 or 3 more minutes, so that beyond their allotted time, so that they can conclude in a better manner, and through which, of course, since this chamber works on the directives of the speaker, so ultimately all the usual mic arrangements are under the jurisdiction of the speaker also. However, last important point which we need to note over here are the acquisitions which are leveled up, or the aspersions which were raised by Rahul Gandhi against Om Birla actually caused for a breach of privilege. That Mr. Om Birla actually provided for a breach of privilege by not allowing the MP, which is Rahul Gandhi, to speak. So ultimately, since our privileges which are being provided by the constitution are not codified, so there is no hard and fast rule which will define that this contributes to a breach of privilege. So if Rahul Gandhi or any MP in that matter, if they feel that they have been stopped from speaking in the parliament or expressing their opinion in the parliament by switching off the mic, they can go to the ethics committee or the privileges committee, and they can raise their issue in the parliamentary committee itself. So this was all for this particular issue. Now let's come to the next topic for discussion is tracking accused on bail. So just like the topic of Neurorights, where we discussed the intersection of technology and how it had impacted the rights jurisprudence of any country. In this topic, again, we are going to discuss how does technology impacts the administration of justice. So what is this case all about? So recently, the Supreme Court of our country has held that the courts of law, whether be it any law, when they are providing bail under the NDPS Act of 1985, they cannot cite such conditions to the accused where when that particular accused, when he is on bail, they have to provide their real-time location through Google Maps. And this was a major bone of contention, which was ultimately the core essence of the Supreme Court judgment. So now let us try to understand this core issue. The approach we are going to follow is the same. We'll look into the background of the case. Secondly, we'll try to see what was the observation of the Supreme Court, and thirdly, what are the major implications of that particular thing. Now, since we know the core essence of this particular topic, now since this core topic belonged to the core issue of that the bail conditions cannot be drafted in a way that the accused has to provide for real-time Google Maps data of their own movement. So similar kind of activities have been done by various investigative agencies of our country as well. For example, Jammu and Kashmir police uses this GPS anklet as well on the people who are accused of severe charges under UAPA or National Security Act or Public Safety Act. And whenever these people are on bail, ultimately they have to wear this GPS anklet through which the police of that particular state or any investigative agency for that sort, they will be able to track the real-time location of that particular accused. Now, what had happened in this particular case is that the Delhi High Court provided bail to a particular Nigerian citizen who was accused under the NDPS Act of 1985. NDPS Act of 1985 deals with narcotics and drug trafficking, etc. Now, in this bail, it provided for two conditions. Firstly, that this particular Nigerian citizen, while he will be on bail, he has to provide for his location through Google Maps. And secondly, he should submit a certificate of assurance. And who will give this certificate of assurance? Will be provided by the Nigerian embassy, and these two things will be submitted to the police. Now, what Supreme Court did is that Supreme Court observed that whenever a court is trying to provide bail to any accused, they should abjure from providing such kind of bail conditions to the accused. However, one important thing which we need to note over here is that the Delhi High Court did not obligate the accused with such conditions out of its own legal innovation. Delhi High Court was following the Supreme Court judgment of the year of 2014 itself. So now let us try to look to that particular judgment. So Supreme Court, there was a very important case by the name of Supreme Court Legal Aid Committee representing prisoners versus Union of India in the year of 1994. Now, what had happened in this particular case is that the Supreme Court Legal Committee were putting forth the interest of the under trials lodged up in our Indian prisons. Now, as we know that the NDPS Act is quite cumbersome and the disposal rate in this case is extremely low. And what happens is that a lot of people end up languishing in the prisons for years and years, almost equivalent to the maximum time of imprisonment they could have got if they were convicted under that particular offense. So what did the Supreme Court noted in this particular judgment is that if there is a case that if a person is accused of offense under NDPS for more than 10 years of imprisonment, secondly, if the person has already spent more than half of the time for which he will be imprisoned to, in that case, the court may grant that particular accused bail on two conditions. One is to provide the GPS location through Google Maps, and secondly, through the certificate of assurance which has to be provided by the concerned embassy of that particular accused, if that particular accused is a foreign national. However, the Supreme Court in this case, they toppled this judgment or the directives which the Supreme Court has provided in this judgment. Now, what did the Supreme Court noted in this judgment is that Supreme Court noted that ultimately by asking for the constant real-time locational data of the accused, it is violating the Article 21 or the right to life and personal liberty of the accused, and it is violating of the Constitution. Secondly, it is also providing that ultimately the certificate of assurance which has to be provided by the embassy, it is not under the ambit of the accused, that whether the embassy will definitely provide them with the certificate of assurance or not. So ultimately it provides a double whammy to the accused, and that is why Supreme Court took away this particular requirement while receiving a bail. And what can be the implications of these things? However, it seems to be progressing the idea, the whole idea is progressing the Article 21, that is the right to privacy and personal liberty. However, there are finer issues associated with it. Now, what are the major implications associated with it? Now, since Supreme Court has disallowed all the courts to include such kind of conditions while providing bail, there is going to be even more further denial of bail with respect to under trials. So, since the court will not be able to provide such conditions, so the number of bails which are provided will definitely go down. Ultimately, it will lead to further increase of under trials in the prisons of our country. Thirdly, it will lead to more resources for the maintenance of these under trials, because these under trials have to eat, have to wear clothes, and have to be administered. So ultimately human resource cost will also come in over here. And fourthly, it will lead to burdening of judiciary. So the pendency levels will increase. And lastly, since the judiciary is not able to provide speedy justice to the under trials, ultimately the trust in the judiciary will go down. And that was the major issue that you had to understand with respect to this topic. So this was all for this topic.